Welcome to Swayam MOOC course NGOs and Sustainable Development. We have now come to the last unit, Unit 5. So, we will see Module 33, which is Need of Legal Framework and its Enforcement. Learning Objectives. By the end of this module, you will be able to understand the basic legal terminologies, learn about the various acts which are in force in India. A collection of documents known as legal framework includes constitution, laws, rules and contracts. A legal hierarchy as seen in the pyramid describes how these documents relate to one another, which has more force than the other. Now, as shown in the pyramid, we have the constitution at the bottom layer, and this is superseded by the policy and legislation. At the top we have the regulation and the model contract, and at the topmost layer we have the contracts. Each instrument gets more precise or specific as it moves up from the base to the top. The instruments at the top of the pyramid should be consistent with those at the bottom. A nation would not consent to contract terms that contravene with laws outlined in regulations, legislations or the constitution in a system where the legal hierarchy is correctly arranged. Additionally, laws and policies are intended to be more powerful than contracts and to take precedence. However, in actuality, contracts can also be drafted to expressly supersede rules and laws. Now, let us see what is constitution. A constitution lays down the fundamental framework of a government as well as the duties and rights of the constituents. Constitutions serve as a guiding documents and are difficult to change, sometimes requiring a supermajority in the legislature or through a popular vote. Now, what is policy? A logical set of guidelines for regulating behavior in the industry should be provided by the national laws and policies. Many nations create formal petroleum or mineral sector policies, for example, to lay a fundamental set of values and objectives that will guide all other laws and actions. Legislation. What is legislation? A policy's vision is governed by legislation, a collection of rules with a legal force. Changing the rules included in the legislation in democracies necessitates the parliamentary approval. Since legislation is often developed through a process requiring action from both the legislatures as well as the administrative wing of the government. Most nations with abundant natural resources have legislations that focuses on the natural resources. Say for example, in our country the natural resources are coal and oil. Additionally, more general laws such as those governing the environment, labor, taxes and land management frequently make up a significant portion of the regulations for business. Now, what is regulation? In order to make a law workable, an executive body of the government creates the regulations, which are typically the implementing rules. They frequently refer to a legislature, but give more specific information. Different nations have different procedures for making the regulation, but in many cases a branch of the executive such as a ministry or a cabinet will act collectively, and this has the authority to do the regulations. Model contract. An example contract or a prototype contract serves as a model for agreements between the government and the corporate sector. In other circumstances, the sample contract is used as a starting point and more significant alterations is permitted as part of the specific regulations. By fixing some of the characteristics that would otherwise be subject to negotiations, nations can strengthen their leverage and decrease the need for protracted discussions by employing model contracts. Some governments have made the usage of model contracts more official by making them part of the regulation or legislation. In other nations, the model is more of a directive produced by the government or state owned enterprises in charge of granting licenses or negotiating contracts. Now, what is a contract? Agreement between two or more parties are called contracts. A contract solely affects the parties who are party to it and the particular region in question, unlike the laws which are applicable throughout the country. The roles and obligations that are not explicitly stated by the law are laid down in a contract. Terms pertaining to operational, financial, social, environmental, further production requirements also are specified in a contract. Now, what do we mean by a legal framework? A legal framework refers to the body of rules, laws and regulations that are applicable in a specific nation. The rights and obligation of governments, businesses and citizens are governed by laws that apply to each project to extract the natural resources from the ground. An overall set of laws is referred to as a legal framework or a legal architecture. Different nations have different processes for defining these rules and different parties get involved. The legal system that governs the extractive industries is part of a larger set of laws that also govern how the state is organized and how business is conducted. A well designed legal framework should regulate the organization of state institutions, should know how businesses obtain and manage licenses. It also should deal with the financial terms under which businesses pay to the government, the management of the environment. The interaction between different projects have to be spelled out in the legal framework documents. The communities around them, the conduct of public official meetings that is involved in the sector, all this has to be spelled out in the legal framework. Further, the disclosure and the accountability to the public is very essential. So, mandatory disclosure documents have to be spelled out. Further, the management of tax revenues when natural resources are used have to be clearly spelled out in the legal framework. Before starting to conduct businesses in a nation, companies must ensure that they are in conformity with or adhering to all the rules and regulations that the country has agreed to in the conventions which is held in internationally. The term legal framework is defined broadly to encompass laws, mechanisms, policies, plans, etc. Now, in India, how does it work? The legal and regulatory framework for environmental protection. Over the years, together with spreading of the environmental consciousness, there has been a change in the traditionally held perception that there is a trade-off between environmental quality and economic growth, as people have come to believe that the two are necessarily complementary. The current focus on environment is not new. Environmental considerations have been an integral part of the Indian culture. The need for conservation and sustainable use of natural resources has been even expressed in the old Indian scriptures, more than 3000 years old, and is reflected in the constitutional, legislature and policy framework, as also in the international commitments by the country. Even before India's independence in 1947, several environmental legislations existed, but the real impetus for bringing about a well-developed framework came only after the UN Conference on Human Environment, which was held in Stockholm 1972. This was the shift where the importance of environment was stressed and documentary evidences came into existence in India. Under the influence of this declaration, the National Council for Environmental Policy and Planning within the Department of Science and Technology, which is the DST, was set up in 1972. This council later evolved into a full-fledged ministry, which is the Ministry of Environment and Forests, which is called as the MOEF in 1985, which today is the apex, the topmost administrative body in the country for regulating and ensuring environmental protection. Since the 1970s, an extensive network of environmental legislation has grown in the country. The Ministry of Environment and Forests and the consequent pollution control boards, which is the Central Pollution Control Board, which is the CPCB, and the State Pollution Control Board, which is the SPCB, came into existence, and together they are involved in the regulatory and the administration of the environment and taking care of the environment, regulating the environment among the industries. A policy framework has also been developed to complement the legislative provisions. The policy statement for abatement of pollution and the National Conservation Strategy and Policy Statement on Environment and Development were brought out by the Ministry of Environment and Forests in 1992. This is to develop and promote initiatives for the protection and the improvement of the environment in India. The EAP, which is the Environment Action Program, was formulated in 1993 with the objective of improving environmental services and integrating environmental considerations into the development programs. So, now let us see the regulatory framework in India prior to independence. Before independence, the environmental related laws in India were mostly associated with various types of pollution. To give some perspective, the Shore in Nuisance, that is in Bombay and Colaba Act of 1853, imposed restriction on the fouling of sea water. The Wild Birds and Animals Protection Act of 1912 aimed to make better provisions for protection and preservation of specific birds and animals. The Bengal Smoke Insurance Act of 1905 was actually the country's first law for protecting nature. The act framed for abatement of nuisances arising from the smoke of furnaces and the fireplace in certain areas of West Bengal. Now coming to the post-independence era, which is after 1947. India's first post-independence environment related policy came into existence around 1972 after the the first UN conference on the human environment, which is the UNCHE, which saw discussions on global environment and the development needs. The National Council for Environmental Policy and Planning was set up in the same year under the Department of Science and Technology. The council later evolved into the Ministry of Environment and Forests in 1985, and further climate change was also brought into its control during 2014. Currently, India has strict environmental legislations, but this is not enough. In India, three primary organizations, that is the State Pollution Control Board at the state level, the Central Pollution Board at the national level, and the Ministry for Environment, Forests and Climate Change. They adopt, they carry out and they enforce environmental regulations. The period around 1970 to 80 was marked with central government initiating various laws and acts for environmental protection, such as the Water Prevention and Pollution Control Act of 1974, Air Prevention and Control of Pollution Act of 1981, the Wildlife Protection Act of 1972, the Forest Conservation Act of 1980. However, in this lecture, in this module, we will see some of the most important acts that was legislated in India. The Environmental Protection Act of 1986, which is known as the EPA Act of 1986, is a very important legislative initiative, and this was carried out to protect and conserve the environment through interventions such as setting up of standards for emission, regulating the location of manufacturing plants, whether the plants should be commissioned or not, management of hazardous waste were some of the provisions that the Act had presented. This Act is also known as the umbrella legislation. It is designed to provide a framework for the coordination of the state and the central authorities established under the Water Prevention and Control Act of 1974, Air Prevention and Control Act of 1981. Under this act, the central government is empowered to take measures necessary to protect and improve the quality of the environment by setting standards for emissions and discharges, regulating the location of industries, management of hazardous waste, and protection of public health and welfare. From time to time, the central government issues notifications under the EPA for the protection of ecologically sensitive areas or issues guidelines for matters under the EPA. The National Environment Appellate Authority Act of 1997 is another landmark legislation that came into existence in a bid to tighten the safeguards with respect to restrictions of areas for industrial activity under the Environment Protection Act of 1986. Similar to legislations in other nations, these environmental regulations set requirements for enterprises to adhere to, such as those for industry specific air emissions and discharges. But the issue is that they do not meet the demands of the moment. Other major legislations are the Biological Diversity Act of 2002, enacted for the preservation of biological diversity in India. With an objective to conserve critical environmental resources, the National Environmental Policy of 2006 was introduced by the Union Government. The policy had defined goals and principles, and it clearly stated the environmental protection is an integral part of any development process. Next comes the National Conservation Strategy and the Policy Statement on Environment and Development of 1992 and the National Forest Policy of 1988 together guide the MOEFCC to plan, promote, coordinate and oversee the implementation of environmental as well as forestry policies and programs for the conservation, preservation and protection of the environment. Water quality standards, especially those of drinking water, are set by the ICMR, which is the Indian Council for Medical Research. These bear close resemblance to the WHO standards. The discharge of industrial effluents is regulated by the Indian Standard Codes, and recently water quality standards for coastal water marine waterfalls have also been spelt out. In addition to the general standards, certain specific standards have also been developed for effluent discharges that happens from the industries such as the iron and steel industry, the aluminium, pulp and paper industry, most important the oil refineries, petrochemicals and the thermal power plants. Legislation to control water pollution is very essential. Now coming to the Water Prevention and Control of Pollution Act, which was enacted in 1974. This act represented India's first attempt to comprehensively deal with environmental issues. The act prohibits the discharge of pollutants into the water bodies beyond a given standard and lays down penalties for non-compliance. The act was later amended in 1988 to conform closely with the provisions of the EPA, which is the Environmental Policy Act of 1986. The Water Pollution Prevention (CESS) Act came into existence in 1977. This act provides for a levy and collection of cess on water consumed by industries and local authorities. It aims at augmenting the resources of the central and state boards for prevention and control of water pollution. Following this act, the Water Prevention and Control of Pollution (CESS) rules were formulated in 1978 for defining the standards and indications for the kind of and location of meters that every consumer of water is required to install. Next comes the Air Prevention and Control of Pollution Act of 1981. To counter the problems associated with air pollution, ambient air quality standards were established under the 1981 Act. The Act provides the means for the control and abatement of air pollution. The Act seeks to combat air pollution by prohibiting the use of polluting fuels and substances, as well as by regulating the appliances that give rise to air pollution. Under the Act, establishing or operating any kind of industrial plant in the pollution control area requires the approval and the consent from the state pollution control boards. The boards are also expected to test the air in air pollution control areas, inspect the pollution control equipments that is installed in the manufacturing plants, and check on the manufacturing processes. National Ambient Air Quality Standards, which is the NAAQS, for major pollutants has been notified by the Central Pollution Control Board during 1994. These are deemed to be the levels of air quality necessary with an adequate margin of safety to protect the public health, vegetation as well as property. To empower the central and the state pollution control boards to meet in case of emergencies, the Air Prevention and Control of Pollution Amendment Act of 1987 was enacted. The boards were authorized to take immediate measures to tackle any emergencies, recover any expenses that has been incurred from the offenders. The power to cancel the consent for non-fulfillment of the conditions prescribed has also been emphasized in the Air Act amendment. Next, coming to the Wildlife Protection Act 1972, which was later amended in 1991. The WPA, which is the Wildlife Protection Act, provides for protection of listed species of flora and fauna and establishes a network of ecologically important protected areas. The WPA empowers the state and the central government to declare any area as a wildlife sanctuary, a national park or a closed area. There is a blanket ban on carrying out any industrial activity inside these protected areas. It provides for authorities to administer and implement the act, to regulate the hunting of wild animals, protect specified plants, sanctuaries, national parks and closed areas, restrict trade or commerce in wild animals or animal articles or miscellaneous matters. The Act prohibits hunting of animals except with the permission of authorized officer when an animal has become dangerous to human life or to property. So, also if the animal is disabled or deceased, then the Act allows or gives permission to the officer to take action as deemed necessary. The near total prohibition on hunting was made more effective by the Amendment Act of 1991. Next, coming to the Forest Conservation Act of 1980. This act was adopted to protect and conserve forests. The act restricts the powers of the state in respect of de-reservation of forests and use of forest land for non-forest purposes. The term non-forest purpose includes clearing a forest land for cultivation of crops or plantation or horticulture or any other afforestation measures. In addition to the above acts, there are other acts also. For example, the Atomic Energy Act of 1982 was introduced to deal with radioactive waste. In 1988, we have the Motor Vehicles Act, which was enacted to regulate the vehicular traffic besides ensuring proper packaging, labeling, transportation of hazardous waste. Various aspects of vehicular pollution have also been notified under the EPA Act of 1986. Mass emission standards were notified in 1990 and this was made more stringent during 1996. In 2000, these standards were revised yet again, and for the first time separate obligations for vehicle owners, manufacturers and enforcing agencies were stipulated. In addition, fairly stringent Euro 1 and Euro 2 emission norms were notified by the Supreme Court on April 29, 1999 for the city of Delhi. The notification made it mandatory for car manufacturers to conform to Euro 1 and Euro 2 norms by May 1999 and April 2000 respectively for new non-commercial vehicles which were sold in Delhi. In addition to this, we have the European Union aligned waste management laws which was enacted in India. India updated numerous waste management laws in 2016 to bring India's waste management in line with that of other regions, most notably the European Union. New regulations on hazardous waste, e-waste and plastic trash management were among those that was updated. Authorities added extended producer responsibility to those regulations, which places heavy obligations on the producers and businesses who sell goods in the Indian market. These businesses must adhere to the polluter pay principle in order to reduce the negative influence on the environment throughout the life cycle of their products. With this strategy, manufacturers or the marketing facilities in India must set up systems for gathering, channelizing and returning the products at the end of the useful life cycle. Of course, there are certain penalties when along with these acts. Companies who violate any of these environmental laws or regulation face serious repercussions. In India, violations are subject to a fine up to $1,334, imprisonment of up to 5 years, which is increased to 7 years if the violation persists for 1 year after the date of conviction or both. Certain environmental offences in the US carry sentences of 6 months to a year in prison. The Indian Public Liability Insurance Act of 1991 is also in existence to cover damages to public victims or property due to any mishap that has happened because of hazardous materials. However, these laws are facing the severe problem of implementation at the ground level, making the question, is it effective? Is these acts seriously implemented? So, are these environmental laws in our country understood by the common man? The courts in India largely relied on the Article 21 for applying the law to the decision making process on various perspectives and provisional duties related to the environment. When we fail to protect our environment, it can give rise to many challenges. Hence, administrative and legal strategies are extremely important to ensure environmental harmony. Now, let us see some questions and answers related to this module. Question 1. What is the Environmental Protection Act of 1970? The Environmental Protection Act of 1970 is an act that is established for Environment Protection Authority to make provision with respect to the powers, duties and functions of the authority to make provisions for the protection of the environment and other purposes. What is the Umbrella Act? The Umbrella Act, called the Environment Protection Act, got passed in 1986, encompassing water, air, land and other interrelationships. So, this is an umbrella act which brought all the previous act under its boundary. The act is identified with the Ministry of Environment and Forest as the nodal agency in pollution control. It is known as an umbrella act because it provides the framework to the central government in order to make the coordination between different state as well as central authorities under different acts. Question 3. Who is known as the Green Lawyer? Mahesh Chandra Mehta is a public interest attorney from India. He single-handedly won numerous landmark judgments from India's Supreme Court since 1984, including introducing lead-free gasoline to India and reducing the industrial pollution fouling the Ganga and the Taj Mahal erosion. He was awarded the Goldman Environment Prize in 1996 for his continuous fight in Indian courts against pollution causing industries. He received the famous Raman Magsaysay Award for Asia and for public service in 1997. The Government of India awarded him the civilian honour of Padma Shri in 2016. He is a trustee of people for animals. To summarize, in this module, we have understood basic legal terminologies. We have learnt about the most important acts which are in force in India. In the subsequent modules, we will learn about more acts and their legislations and as well as their content. Thank you.